Hey everybody, welcome back. Thanks again for downloading our content. I'm joined by Bryan Neihart of Alliance Defending Freedom. He is an attorney and they specialize in perfections for protections. We could go either way with that. It's early and I'm stumbling over my words already. It's not early for Bryan. It's midday where you are. Hello, sir. Why don't you introduce us? Geez, it's not a Noggin Notes podcast if we don't have some audio fumbles. Anyway, introduce yourself, please, and we'll dispense with the alleged professionalism here.
Hi, Jake. As you say, my name is Bryan Neihart. I'm senior counsel at Alliance Defending Freedom. For those who may be unfamiliar with Alliance Defending Freedom, we are a Christian nonprofit law firm that's dedicated to keeping the door open for the gospel. And we litigate cases across the country on five major issues, including freedom of speech, freedom of religion, and parental rights. And over the past, since 2011, we've had 20 cases at the Supreme Court where we've won. And in fact, just this past term, we won 4 cases at the U.S. Supreme Court. So we litigate constitutional cases all over the country. And I'm happy and excited to talk about one of those cases, Childs versus Salazar, today.
I want to get into that in a little bit, but first I want to get a bit of background on not only on you, where you come from, why you chose this particular angle, because in law you can do a lot and it can span a lot of different things. But primarily, why these issues? Why religious freedom? Why parental rights? Why free speech? And specifically for you, but also for the nonprofit.
I became interested in religious freedom actually in college. I went to Wheaton College outside of Chicago, and I was majoring in French and international relations, and I was a junior. And so I was kind of thinking, how can I use these majors as an actual career? And I remember attending a lecture given by a State Department official that talked about international religious freedom and how religious minority groups, including Christians and other groups, were being persecuted around the world for their faith. And that lecture kind of opened my eyes to this issue of religious liberty, not only in the United States, but also internationally. And so that at that point, I decided to pursue a career in law because I saw how the law could be used to protect those freedoms in the United States. And so that was always a goal of mine, to work at a law firm like Alliance Defending Freedom. I've been here since 2019. Those specific issues that I mentioned are important because they're each God-given rights that we have independent of any government giving them to us. And they're also important for human flourishing. I think about Christianity and specifically, and God has given us free will, and we can choose to follow him or not. But part of that is having religious freedom, allowing people to find and pursue what they believe to be true, knowing that ultimately the truth that's reflected in the Bible will be the ultimately only true thing. And so freedom of speech, freedom of religion, those issues that I mentioned are part of that pursuit, and are important to protect, to ensure that people can believe and act consistent with their beliefs.
Talk a little bit about parental rights and how that folds in, please. Context for this is that since the COVID lockdowns specifically, and I know it's been going on elsewhere before that and since, but we've really had an assault on what I would refer to, and probably you would also, as parental rights, and that would be the ability to determine our children's future as we see fit, especially in the face of governmental systems that maybe steer things like educational curricula and what seeps into the classroom. And I'm just going to stop there because I don't want to opine and then steal your thunder. You're the guest, but I think we're going to be on the same page here. I'm curious what is going on and what you're seeing and what we can learn from this.
That's right. So since the 1920s, actually, the Supreme Court has recognized that parents have a right to direct the religious upbringing of their children. And that typically happens in the home, but it can also happen in public. And there was a recent Supreme Court case, Mahmoud versus Taylor, where this issue came up, where parents were declined the ability to opt out of certain LGBT ideology that was being taught in their schools. And the Supreme Court said that's a violation of the parents' free exercise rights to decline to that infringed on their ability to direct the upbringing of their children. But that's not just a religious right; it's also a right that other parents enjoy as well, because of the unique and special nature of the parents' relationship with the child. And that goes back to the biblical principles as well. The family is an institution that's created by God and meant to reflect His goodness and His desire to live in community with us.
We've had Chloe Carmichael on. I don't know if you're familiar with Chloe's work, but she's written a couple of books specifically related to free speech in the clinical setting. And I don't necessarily want to rehash her podcast, but she's taken an appropriate, I think, angle toward how free speech is important to mental well-being. And so we're going to get into this in a minute, but the idea of parental rights being usurped by governmental or other public institutions, I guess you could say, infiltration into that relationship between parent and child definitely affects mental well-being, because if parents are stressed about what their children are learning or bringing home, or having conflicting beliefs and ideologies that don't align with the family values, that can certainly have a deleterious effect on their ability to parent, their authority in the home, and then they end up in my office wondering why their children are rebelling, right? So it's interesting to me to see the interweave of mental wellness, psychological principles, free speech, and the law in this realm. And I'm hoping that you can give some context to this, and I'll just ice the cake here and hand it over. I would normally say, for the international audience, I'd like to explain why certain freedoms are protected in the US Constitution that aren't anywhere else. But I've recently discovered, to my chagrin, that US citizens don't understand that the government doesn't give rights through the Constitution. Government is restrained in the limitation of those rights by the Constitution. So if you could give maybe a more articulate explanation of that, and then how it interweaves with the law, and why this is so important, why we're not just, chipping our teeth about, oh, stupid schools, getting my child to recruit into some ideology I don't believe. Like, it's not about that. It's about overall wellness and balance and authority and structure and hierarchy and legal right.
Well, that's right. So, going back to basic principles, of course, the United States was founded on the idea that government is limited and that it doesn't have authoritarian rights. It doesn't have unlimited rights. The rights that it has and the authority that it has is only those that the people give to it. And so the rights that are embodied in the Bill of Rights, which is primarily what we'll be talking about today, are rights that just restrain the government and are recognized, our basic rights as humans that restrain the government. And you think of it as, in terms of our rights as individuals, as a restraint on the government, but also you think of it as our entire structure of government is designed to restrict its authority. That's why we have the three parts of government, and each one of those has oversight over the other, because American founders recognized that humans are sinful, they're prone to mistake, and absolute power, even power corrupts, and absolute power corrupts absolutely. So they designed a system that was intended to restrain that power. But to your point earlier about the unique nature of the American government, it is the U.S. government and state governments too only have authority that's given to them by the people.
And these people now are finding themselves increasingly at odds with that government. And we're supposed to have an opportunity through the legislative process to alter things the way that we see fit, through the judicial process to hold them accountable. You are part of the judicial process. How is this shaking out on behalf of the parents who want their rights recognized as opposed to restricted, right? Like, how are you seeing this? What's the trend? Are people waking up? I have a theory that maybe we got a little fat, dumb, and happy and a little complacent in America because we didn't have to defend a lot of our freedoms. But what's the trend now? Like, what read the tea leaves for me?
Well, I think I'm thankful that we have a U.S. Supreme Court that has been, over the past several years, has been consistently recognizing and reaffirming our constitutional rights as Americans. And you see that with consistent cases that have come out from the court that have generally protected the freedom of speech, the freedom of religion. And so as governments continue to overreach and continue to pass laws that infringe on those rights, we've been thankful to have success at the Supreme Court, and other groups and individuals have had success at the Supreme Court recognizing those First Amendment rights and preventing that type of governmental overreach. But the other thing I would say is this can happen at any level. There's local governments that are responsible for passing laws, state governments, as well as federal government. So I think it is important for us that are concerned with constitutional rights and individual freedoms to be paying attention to what's going on at the local level as well as the national level, to keep apprised of what's going on and to see how we can be involved with combating or resisting laws that are problematic and infringe on constitutional rights.
Let me ask a thornier question here, and I don't mind if we get into the psychological constructs or spiritual constructs of it. Why would people want to restrict each other, from your view? I have my own theory, but I want to hear yours.
Well, I think that just goes back to the human sinfulness. People want to have authority over others and want to be able to control other people, and I think that's part of it. I think there's also a desire to control certain viewpoints and to prioritize certain views and ideas over others as well. And I think, especially in the free speech context, when governments pass laws, one of the most egregious forms of a First Amendment free speech violation is laws that are designed or have the effect of restricting speech because the government disfavors those particular views, or thinks those particular views are offensive, or thinks that those particular ideas are not worth talking about in public. And so that would be a short answer to your question.
I appreciate that. From a systemic, so we study systems for a living, family systems, governmental systems, whatever. In systems, it's a kind of a bizarre concept, and I'm going to try to highlight it real quick here. The system itself will try to maintain its own homeostasis. So you can make what's called a first order change to a system. That might be voting out an elected official and voting a new one in. But that just, it doesn't affect the system itself. The system's going to keep doing what it does. All you did was kind of, repaint a chair on the carousel, so to speak. To affect a second order change, the system itself has to change. And my belief forever and ever, and the more I study human history, the more I come to appreciate this. The system of government will always want to augment itself, which by nature means it has to control the people. America's experiment, as we call it, inverted that. It said that the people are in charge of the government and not the government in charge of the people. But then when you get folks into government who find this power, and you mentioned the Lord Acton quote, as it's often attributed, power corrupts, absolute power corrupts, absolutely. When you get into power, it's very, very hard to fight the urge to be non-attached to the power, because power was given to you by the elected, or even if it's appointed by an elected person. So my view is the only way to fight that is to subordinate oneself and to submit to something higher. Well, what's higher other than God? Now, if you've got a bunch of godless people who think that they themselves are gods of their own universe, it becomes very convenient and very easy to fall into a trap where you don't want to submit and you don't want to subordinate yourself. And then government can become a god of sorts. So it's understandable why these laws would be passed, because as you say, if we don't want idea expression that may threaten the system itself, then the system's going to fight that. And the parts of the system will just go along to get along because they're wedded to the reward structure, what have you. How this plays out for individuals on the ground level, you think very high level, it's like, well, we want to fight the government or whatever if they come after us. It's like, well, they come after you in very pernicious subliminal ways. And one of those ways is through licensing boards. So licensing boards for occupations that require such a thing are alleged to keep and maintain a minimum standard for the occupation, whether it's contracting or dentistry or mental health or cosmetology. They set a minimum standard, And then allegedly they protect the public against bad actors within that standard. And that's all well and good, except when the licensing board, which is the government, starts telling practitioners that it can and cannot do certain things in certain sessions. So that's my bridge to Charles v. Salazar. Would you like to take it from there, sir? And feel free to add things if I miss them.
Sure. Well, that's a great segue. And let me kind of before I get into Charles versus, or let me summarize Charles versus Salazar, and then kind of take several steps back to see how we got there.
Sure.
So Charles versus Salazar, it was a U.S. Supreme Court case decided in March of this year, 2026. ADF represented a counselor from Colorado who was a believer, and she wanted to be able to help children who were struggling with their sexuality or gender identity. So if someone came to her, a child came to her and said, I'm having sexual thoughts or engaging in sexual behavior that's contrary to my faith, can you please help me? She wanted to be able to help that person align their actions and attractions with their faith. Or if a child came to her and said, I'm struggling with my gender identity, can you help me align my sex with my identity? She wanted to be able to help that child in that situation as well. But Colorado had passed a law that it calls a conversion therapy law, which I call a counseling ban, that restricted our client, Kaylee Child's ability to have those conversations with children. And what Colorado's law said was that counselors could encourage children to undergo a gender transition, or they could affirm a child's same-sex attractions, behaviors, or conduct, but they couldn't help that child to change that identity or that sexual orientation, even if the child wanted to, and even if the only thing that was involved in that counseling relationship was a conversation. And so that's why I call it a counseling ban, not a conversion therapy ban. Conversion therapy, many of your audience are probably familiar with that term. That term includes a broad array of conduct. So it includes things that would include aversive techniques and other techniques that have been used in the past. But as governments have looked at this issue more and more, they've adopted these laws that are so broad that they include talk therapy. So when the only thing that is involved in the counseling relationship is talk, these laws are broad enough to cover those types of conversations. So that issue got to the U.S. Supreme Court, and the Supreme Court said that type of speech restriction violates the First Amendment. It violates the First Amendment because a counselor doesn't lose his or her free speech rights just because he or she is licensed by the state. The state doesn't all of a sudden create a no free speech zone by passing licensing laws and regulating licensed professionals. The Supreme Court also said that Colorado's particular law regulated speech based on viewpoint. And the viewpoint was that it's okay to transition your gender. It's okay to have same-sex attractions or behaviors, but it's not okay to grow comfortable with your gender identity consistent with your sex, or to pursue opposite sex relationships or conduct or activities. And so the Supreme Court specifically took on that licensing piece. And typically licensing laws are who can practice a profession. There's specific requirements that allow you to kind of get in the door of the profession itself. But Colorado's law, under the guise of a licensing requirement, actually dictated what the licensed professionals could say and what the licensing professionals could not say. And so that is unlike any type of historical licensing law because it actually regulates the speech of the professionals themselves. But these kinds of laws, Colorado's law didn't come out of nowhere. It was passed in 2019, but this issue actually started in 2012 in California, where California was the first state to pass a conversion therapy law that regulated all types of treatments or practices, including talk therapy, including nothing but speech between a licensed counselor and an individual. And so as soon as California passed that law, it was challenged in court and by different practitioners in California. And they said that these types of laws, when applied to a counselor's private conversations with the client, violate their First Amendment rights of both the counselor and also the client, because the First Amendment includes not just the right to speak, but there's also cases that say it includes the right to receive information. So these laws are harmful because they not only restrict the rights of the counselors, but they also restrict the information that parents can seek on behalf of their children, that children can seek on behalf of themselves. And I keep saying children because these laws typically have only applied to individuals under the age of 18. So a client who's under the age of 18 can't have these conversations with counselors. But if you're over 18, these laws don't apply. And so these cases started in California. The Ninth Circuit, which is the Court of Appeals over California and other states, eventually decided that these types of restrictions actually don't violate the First Amendment, because the restrictions are actually restrictions on conduct and not speech. And they drew on a lot of the principles that you mentioned, which is that, look, the Ninth Circuit said, well, these are licensed professionals. The state has a historic authority to regulate licensed professionals and the standard of care that's applicable to them. So that makes it more like, that gives the state more authority in this area. The state has also defined the counseling as like a medical treatment. And so the counseling, even if it involves pure speech, is more akin to prescribing medications or performing a surgery or something like that. And so the state can regulate it because the speech is treatment and is therefore conduct.
Right. That was what I was always taught in grad school. Yep.
Right. And the First Amendment free speech clause, of course, only applies to speech and not conduct. And so by the courts defining the counseling as conduct is kind of an in run around the free speech clause. And so that was 2012, 2014, when those cases were coming up. As those cases were coming up, more and more places across the country began passing similar types of speech restrictions. And so by the time this issue reached the Supreme Court in Childs versus Salazar, there were over 20 states that had these types of counseling bans, and over 100 local jurisdictions that had similar types of bans. Sometimes those would be in states that had comparable bans. Sometimes they would be in states that didn't have these kinds of bans. So it was a nationwide issue. And as, of course, more and more places passed these laws, more and more cases came up. And so what eventually happened was you had a split of authority between different courts in the country. Some courts agreed with the Ninth Circuit and said, yeah, these types of conversations are actually conduct, and the free speech clause doesn't apply there. Other courts said, no, when the thing that's being regulated is just speech and nothing else, that triggers the First Amendment, because the First Amendment protects speech. And so by regulating the speech, the laws are in First Amendment world, and they're unconstitutional under the First Amendment because they regulate speech based on viewpoint expressed. And so you had that difference of opinion amongst the courts, and eventually the Supreme Court decided to take a look at it, which is typical when there's a split of authority in lower courts that's been ongoing. The Supreme Court will oftentimes take the case to resolve that split. And so that was some of the background for the Childs versus Salazar opinion.
Okay. So we also have overlaid on this AB 2098, which was an attempt to regulate speech in the doctor's offices of physicians in California. I'm sure you're aware of that. It ended up, I think it passed, but didn't get a governor's signature or something like that. Maybe it was sued and overturned. I can't remember. Do you remember the particulars of that? It was like 2021.
I don't remember that specific one, but I have seen cases that have sought to regulate, the speech of physicians unrelated to the actual treatment that they're providing. And so it's an important difference. If a doctor is prescribing medication, for example, or performing a surgery, they can be required to ask the patient or talk to the patient about the risks and benefits of the surgery or of the prescription. And in some ways that's speech, because the physician is being told, you have to say these words to explain to the patient what is going on and what could happen. And the courts have said that's okay, even though it involves speech, because the actual thing that's being regulated there is the surgery or is the medical prescription. And those types of things are not speech. And so it's called, speech incidental to conduct. The problem, though, is that again, on the licensing issue, just because you're a licensed physician doesn't mean the state can dictate every other thing that you say
Right,
to
like your ex posts or
that's right.
seminars or what have you, right?
That's right. That's exactly right. And so I have seen those kinds of cases come up, and the principles of Childs versus Salazar that the licensing professions don't lose First Amendment rights apply equally to physicians as they do to counselors, as they do to any other type of licensed professional, including thankfully for me, lawyers.
Right. Yeah, because I could see the bar doing the same thing in various states. So what happened in California was there was an attempt to regulate the doctors into prescribing and treating, this was a COVID related issue, only what the CDC had authorized, right? So if you wanted to administer ivermectin for COVID, they weren't allowed to do that because it broke from this quote unquote standard. And standards change like the wind. So the doctors pushed back essentially and said, you're inhibiting my right to practice as I see fit. And now you're limiting my scope. And that was, unacceptable to them, which I agree. And in my realm, it would be akin to a licensing board saying, you're only allowed to do cognitive behavioral therapy. You're not allowed to do psychodynamic. Right. And it's like, well, says who? It's like, well, says the CBT lobby, which got into the government and only wants you to do there. And so I think that speech is important for all these things that, allow freedom of expression, freedom of exploration of treatment and modalities and intervention strategies, but also the stress alleviation for a practicing professional to say, hey, what brings you great comfort? Well, what brings me great comfort is prayer and church attendance and my faith in Christ or whatever it is. And I go, well, I think you should do more of that. As soon as those words escape my mouth, I have essentially recommended a treatment course. And if the government isn't interested in allowing me to do that, then I could potentially find myself askance with the according to government regulations or standards. Similarly, and this bridges into some other stuff that I do, and the audience is aware of this, that the guns and mental health efforts. So through Walk the Talk America, we're bridging the gap between firearms ownership and mental health care. And one of the things that we're presenting to people is if you're a gun owner and shooting 1,000 rounds in the desert alleviates your stress or your PTSD or your anxiety or your depression, I'm going to prescribe that to you. Now, there is a whole bunch of people who don't think that that's a good idea. That's fine, but I should be allowed to have the idea. And I'm wondering if you're experiencing any of these modality intervention related issues in your realm, or have you heard of this? Because this is something we're concerned with in my field about whether or not the government is going to step in at behest of some lobby group that says suddenly you're not allowed to practice this way, you must only practice this way because there's money behind it or something.
Well, this is a really important issue, and you raise a really good point. And when in the Child's case, for example, there were lots of associations that claimed that there was harm associated with talk therapy
Right.
and helping children to align their gender with their sex. And Colorado and lots of governments have relied on the statements of these associations to say, see, these associations say it's harmful, therefore that's the standard of care. We're adopting these associations' standard of care.
Right. Now, that's a very popular position to take, especially with children, protect the children, public health, safety, blah, 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 right? It's hard to argue against that.
Exactly. And there's two issues with that. One we can get into a little bit if you'd like to, but I'll focus on the second one. The first issue is do these associations and the studies they rely on, do they actually show that the speech restriction, the speech that is restricted causes harm, or is there just a possibility of potential harm?
Yeah, spoiler alert, no, we've already figured that out from the WPATH files.
That's right. That's right. And and then there's also the sub issue there of how these associations are even going about promoting certain position statements. But the other issue that I want to focus on is the fact that the Supreme Court made the point that governments can't outsource their authority to private associations to make those types of determinations, because private associations make mistakes and they're wrong and positions change. And to your point about the CBT lobby, or other things, they oftentimes have certain ideological motivations or other things that push them towards a particular position. But even beyond that, the science changes, especially in this area, pretty regularly. And so it's ineffective and harmful, actually, to isolate and freeze in amber any one particular type of treatment when there's constant evolution of the science and what's helpful to children and those kinds of things. And the Supreme Court made the point, and I thought this was really powerful, that in the 1970s, the American Psychological Association labeled homosexuality as a mental disorder. And so the Supreme Court said if states just outsourced that determination to private associations, they would be able to restrict speech that would promote homosexuality. And so that's one of the reasons why the Supreme Court said you can't outsource these types of decisions to private associations to make these kinds of determinations.
I want to pick your brain on something there. You make a really good point about the science ever changing because we have a well-known replication crisis in this field, particularly in psychology broadly, is that people will produce a result from some study and then other people will try to replicate it and they can't. And it's been known as the replication crisis. It's been going on for probably 20 years now. And so we have these articles and journals that are published by fancy sounding people in fancy journals with large reach, and they become accepted as the standard. And then somebody else says, well, what about this other piece of data that we have? And they're suppressed because of various political reasons or money. And so we have a well-known replication crisis. So to your point, that's not just somebody's idea about someday in the future we may find something more about the brain and we don't therefore want to codify it in statute. But to that end, in my state, Nevada, we have in our statutory laws and then our regulatory code something that has a phraseology of adopted by reference. And what we've adopted by reference is the ethical codes of our association. So my particular licensing board governs two different licenses, marriage and family therapists and clinical professional counselors. They're called licensed professional counselors elsewhere, but here they're CPCs. Social workers are different. Psychologists have a different board. Drug and alcohol has a different board. Anyway, on my board, forever and ever, we had adopted by reference the ethical codes of the American Association of Marriage and Family Therapy and the National Board for Certified Counselors. And the logic tracked because those were the two entities that created the test by which we would affirm our competence and therefore get granted our licensure. And so if you fell into one camp or the other, your license would be, would have to adhere to the ethical codes of one organization or the other. Nobody really knew whether or not both applied or either, but it was understood, right? Well, recently they adopted another one by reference, which is the American Counseling Association. So now we go, well, which one are we applying? And the matrix of overlay does not always track perfectly. Otherwise, we would just have one. Now, somebody bearing my resemblance and sounding a lot like me once upon a time advocated that we should change all that and just take on a Nevada state ethics code because my intentionality behind this was such that if I choose not to have membership in any of those associations because I have strongly convicted personal reasons, then the state probably shouldn't be allowed to hold me to those standards if I disagree for one reason or another. I'm curious your opinion on that and whether or not the proper way should be, I think the proper way should be to go through the legislative process, ask for a regulatory change through the rulemaking procedures, and just eliminate all that, and then create a Nevada state ethics code that can adhere to all to which all licensees can adhere, and get rid of the private associations. But is there a potential court challenge here where we just don't even ask for permission through the legislature and we say, this is stupid, we're suing you because a whole bunch of licensees aren't represented by these associations? Because otherwise I could just point to other associations and there's like 9 or 10 of them. All of them have ethical codes that I could say, well, why don't you fold these in? I want that one. And then we're picking and choosing. What's your take on that? Or what's the associations or the alliances take?
Well, I think you're right that there is a problem with incorporating outside ethics codes into the legislation, partly because there's just a vagueness issue there when the ethics codes may change more frequently than the law itself changes, and you're not sure which one is the applicable one or not. There's also the issue of typically these private associations are not regulated by the First Amendment in the same way that governments are. So in other words, if you have
Right, because they're private.
Because they're private. That's right. Because the First Amendment prohibits the government from acting. It doesn't prohibit private parties from acting. And so that's another issue that's a problem in a lot of these situations is if you have an objection to something that a private association is requiring you to say, that there's not necessarily a First Amendment protection there. I think
Right.
it's a
You
little
just
different.
leave and surrender your membership, and then you move on with life and find somebody you do like. But if it's government adopting this, then it's a problem.
That's right, and that would potentially trigger the First Amendment when the government's adopting these ethics codes. It kind of is incorporating them by reference into those laws. But but so there are lots of problems with just incorporating by reference as you're suggesting, and then there's also the problem, as you said, about which associations are the ones that are authoritative and which ones are not. Some are more authoritative than others, and some have more legitimacy than others. And so, how are those selected and chosen? And what happens if an association is at one time credible and then loses its credibility? How does that affect the law? And so, there's lots of issues with that versus what you're describing is going back to limited government, legislative process where you get input from the stakeholders that can provide legitimate explanations for why certain code is ethical or why a certain requirement may be ethical or not, or why it might be wise or unwise to include certain requirements in those statutory or regulatory codes. And that seems like a better approach to me.
Right. It makes it a lot less piecemeal too, and then we don't have to worry about which conflicting ethical codes are being applied. Talk to me a little bit about whether or not you or some of your colleagues have encountered this unprofessional conduct thing, because my understanding is that the unprofessional conduct, again, overly vague, overly broad, applies only to conduct in setting, professional setting, not in public. So if I go out and I want to protest something in front of the courthouse with my sign and I offend some people, they can't go to my licensing board and say Jake is acting unprofessionally because he's causing harm, because Jake's not in the professional setting. Is that your understanding of that phrase, unprofessional conduct, or is it broader than that?
I think generally that's correct, but I've also seen some requirements that it might apply to beyond just your professional setting. But the unprofessional conduct label is important. Going back to Childs versus Salazar, because the label suggests, again, conduct that you're engaging in that is unprofessional. And as we've talked about, conduct is not protected by the First Amendment in the same way that speech is. But sometimes the governments have included disfavored speech as a form of unprofessional conduct. And that's essentially what the counseling ban in Colorado did. It said you engage in unprofessional conduct if you engage in what the state defined as conversion therapy. And so it's defining unprofessional conduct in a way that is viewpoint discriminatory against certain types of speech. And I think that's something to keep in mind too. Is just because the state or licensing board has labeled something unprofessional conduct, it's important to look at what's actually defined to be unprofessional conduct. And if that label includes some sort of expression, then that's a problem.
Are we, in your estimation, clear in other areas of the country? Because now this is a SCOTUS decision. Are we clear to interpret speech does not equal conduct, or can speech sometimes be conduct still?
So the Supreme Court said is that when the counseling is nothing but talk therapy, so it's just simply a conversation between a counselor and a client, that is speech that's protected by the First Amendment. Um, so I think that's pretty well settled. Now, going back to the physician example that we talked about, when there's speech that's intermingled with conduct, that is more of a case by case basis to see which one is the thing that's actually being regulated and which one is the purpose of the regulation. Is it the speech, which is a problem, or is it really the conduct, which doesn't have the same constitutional implications as when a regulation is just specifically targeted and focused on the speech itself?
Right, because the next question I have is where is the line drawn between speech and treatment and conduct and treatment? Because I could see some people playing fast and loose with the rules if they wanted to abuse their power differential in the session and start sexually harassing their patients. And they go, no, Ollie Oxenfree, it's just speech, right? And that's not appropriate either. That would be definitely a conduct violation. where do we allege this? How do we find that? I know it's hard to prove, but this hypothetical, we're going to assume that victim proves it, says, yes, my therapist sexually harassed me, made nasty comments about my face, or made fun of my disheveled look. Okay, that would, I would say, would be unprofessional conduct. Also a speech issue, but you're just being a jerk, and we don't like that as a licensing board. We want jerks licensed in our state. What's your take on that?
Well, let me go back to something you mentioned. You mentioned it as framed it as treatment versus speech or treatment versus
Versus
conduct.
conduct, yeah.
And one thing just to keep in mind is, and that's important, is just because it's labeled as treatment doesn't mean it's not speech. And so the real distinction is not between treatment and speech or treatment and conduct, but between speech and conduct. So again, the governments can't restrict speech simply by labeling it as a medical treatment, and that's what
Right.
courts had tried to do in these counseling restrictions. But to your point, more generally, there is the line's not always clear what is speech and what is conduct, but there is definitely a line that people are familiar with drawing between something that is just conduct and something that is just speech. And so um, conversations are that involve just words that are voluntary are entirely speech. Situations, physical altercations, obviously conduct. So there's lots of clear lines between what is speech and what is conduct. And one of the tests that the courts use is, does the speaker intend to convey a message by the expression that they're giving? And then also, would someone understand that there is an intent to give a message? And even within that, there's certain things that are clearly speech and clearly not. So words are speech. Again, I mentioned a physical altercation, that's not speech. But sometimes new situations come up where courts have to see, is this more similar to speech or is this more similar to conduct? And so there's actually an interesting case from California that went to the Supreme Court, where the Supreme Court had to look at video games, and say, are video games expression or video games conduct? And what the court said was, well, let's look to like history, and are video games more similar to books or movies, which are clearly expressive, or are they more similar to something else? And the Supreme Court said, well, video games have a plot and they have different features of them that make them comparable to books or videos, and so therefore their speech. And so all that to say is there's lots of tests that courts use to make that distinction. And I think courts are generally capable of doing that, especially when you have guidance from Childs that explain you can't just relabel something as conduct and then all of a sudden it becomes conduct when the thing that's actually being regulated is a conversation.
Yeah, that's great news for those of us who want to be able to practice freely. I want to shift just for, I don't know, honor your time too, shift a little bit and talk in the next 5 or 6 minutes about a different case. Are you aware of Anna Runkle? She goes by the Crappy Childhood Fairy on YouTube.
No.
Is it? Okay, so Anna has incurred the wrath of the California Board of Behavioral Sciences and the psychology folks because she has run a very, very popular YouTube channel, basically just dispensing wisdom about how she healed her own issues. And someone somewhere decided that they got a wild hair up their nose and came after her and alleged her practicing without a license and is trying to shut her down. She's now invoked some legal counsel from a different entity, Pacific Legal Defense, I think, and they are doing it pro bono for her. And the issue with her is she is a non-licensee, just talking. And of course, certain people took offense at that because apparently there's not enough hurt to go around or something. And so they want to shut her down and kill her business. And the allegation is that she's practicing without a license because California has overly broadly defined the practice of psychology as, well, whatever they say it is, and psychological principles as whatever they say they are. And so right now the news is that she got an injunction. She's still allowed to have her YouTube channel up while the lawsuit progresses, but she's essentially suing the state of California saying, you're overreaching here. I'm just a person on a channel talking to people. You don't get to tell me I can't. And they said, well, naughty, naughty, you live in California, therefore, if we decide that you're practicing psychology, then it's psychology. So she's essentially asking for relief there. And outside of the licensing realm, uh, people who are life coaches or who are just super talented at talking to people are seemingly coming under greater and greater pressure from these licensing entities, which I think probably are done at the behest of the professional associations because there's this weird guild protectionism, turf waring, purity of the blood thing that's like they're stealing our jobs or whatever, as if we've cornered the market on human healing in the last 5 minutes of human history, right? So, are you seeing any of this on your slate? Is this in your consciousness or your awareness where normal people with business licenses charging folks to talk to them, to coach them, consult, corporations, private, public, individual, or collective? Are you seeing any of this outside of the Anna, which you already said you don't know about her, but are you seeing any of that?
Yeah, so I would say going back to what we the desire for authority, as we talked about, I think when licensing, I have noticed in some situations where boards recognizing that there's areas that may affect the practice, but that are unregulated, a desire to regulate those fields. And I think there is a little bit of a tension there because um, there is some I could see some benefit to ensuring that people that hold themselves out to be licensed counselors, for example, are actually licensed counselors.
Oh, sure, sure.
And I think that's typically how these types of boards go after situations like you're describing is they're holding themselves out to be a counselor, and that's what the problem is.
Right.
But beyond that, just speaking and giving advice, on YouTube or in public, is again quintessentially protected First Amendment speech. And so, if it's an individual that's unregulated by the field and they're not holding themselves out to be a counselor, they're just offering their advice, then that's a problem.
So at some point, I would anticipate there will be suits brought from individuals who are non-licensed, alleging the overreach of boards who have boards, not a who, boards which have added language. So it's right now in Nevada, for example, it's you can't advertise yourself as a marriage therapist, marriage and family therapist, marriage and family counselor, psychologist, all the protected language. But then they could encroach to coach, consultant, right? So in California, if you're a psychologist and you're a psychologist in California, you're allowed to be a consultant. But Board of Psychology said consultation is a protected word. You're not allowed to consult unless you're a psychologist, which to me sounds ludicrous. In Nevada, I apparently can't drive over to California and consult the San Francisco Giants on whether or not they should, do one thing or another. Otherwise, the board will come after me. So that I can anticipate that if the authoritarians continue their authoritative overreach, and start adding words to the protected language that we're not allowed to use if we're non-licensed.
Yes, well, to your point, there have been cases across the country that have challenged the licensing structure in its entirety, and those cases have come out. The ones I'm familiar with have come out in varying ways, but for sure, once the authority it continues to expand, or once the board or the legislature expands the board's authority beyond what's actually being regulated, the broader the authority gets, the more likely it is to encroach on these First Amendment freedoms. And when the definition is so broad of who is a counselor, who is a practicing professional, that it includes everyday Americans, that overbreadth issue is a problem if they take on to themselves the authority to prosecute those individuals or to punish those individuals.
Yeah, and I got to think, put a bow on this. My hypothesis here is that our field has gotten so terrible at what it does, uh, because we're just failing to produce high quality talent, that I think that there's a handful of people who have surrendered their licenses and decided I don't want this stuff anymore. I'm just going to go do it on my own and have the market decide whether or not I'm worth paying. And then there's those who just have great life experience. A lot of veterans out there doing this stuff too and saying, "Hey, I'm smart. I know things. I've read a lot of books. I've had life experience. I can go help people." And those are starting to erode the actual professional license people who have forever and ever held themselves out as the high standard. Now they're not the high standard anymore. And I think there's probably just a fear that, oh no, we're going to go away because, well, look at yourselves in the mirror, get better at what you do, and then you don't have to worry about it. It's just this fear of market competition, I think, driving a lot of this stuff. And so they're using the states to restrict the the fields, I guess, the ability to employ oneself, and I find that incredibly distasteful. But I think that's the dynamic. We're just not very good anymore, and people are literally taking our jobs. Well,
Well,
Yeah, go ahead.
Yeah, you know more about the inner workings of the profession than I would, but like I mentioned earlier, I think licensing boards typically are allowed to decide who practices within the profession, but then as that uh, attempts to grab authority or expand influence gets broader, that's when there's these issues that can come up with prosecuting the YouTube or prosecuting someone for or punishing someone who is engaged in, who's not licensed, that's engaged in something that the board thinks is problematic.
Yeah, eating burgers and charging money for it. Like I'll dispense some wisdom if you buy me a burger. Hey, you, that's not within your scope.
Right.
Well, thanks, Brian. I really appreciate your time. I know that you've got lots of work to do, and so carving out this hour for us has been beneficial to me. I'm honored. Uh, Go over the website again, please. Your affiliation with Alliance, and tell people how they might be able to reach you and or your folks, please.
Yes, it's Alliance Defending Freedom is the name of my law firm. ADFlegal.org is our website. And the other thing that I'll say to your listeners is we take thousands of calls throughout the year for people that are facing legal issues or have questions about legal matters. And so if you're a counselor in a state that has some of these issues that we've talked about, feel free to reach out to adflegal.org. And there's a section on there where you can fill out a form that is an intake form that will direct your question to the appropriate person. So I would flag that for your listeners. But thank you so much for having me this morning. It's been great talking with you, and I've appreciated your time.
Thanks, man. On behalf of our Zephyr Wellness family and the Noggin Notes team, we wish you all great mental wellness. Bye bye.